petitioner shall serve on the counsel who represented the respondents in the trial proceedings or by way of hand summons. Yes. Pendency of this petition will not alter the rights that are already crystallized in favor of the respondents. Next. Notice. You're state.
KDB 1 to 4 response.
KDB, yeah?
Yes.
Yara pera?
PN Hatti sir.
PN Hatti. So and so. Accepts notice, is directed to accept notice for the respondent, requisite set of papers, list the matter after
representation.
After next week, ಇವತ್ತೇ serve ಮಾಡಿ. Next Monday fresh matters. Next Monday ಬೇಡ. 16th. Same. Representation. Government. Karnataka Vikasa Gramin Bank, yaar. You should come with the answer. Yaar? So and so. Learned counsel so and so accepts notice for the respondent. Registry to print the name of so and so as appearing for the respondent. Both Eradu, 14, 15 and 17. Correct. 14, 15, 17. Take notice. Petitioner to serve set of papers upon the aforesaid counsel. List the matter. This mandamus ashte. Will question idya? ಏನು ಆರ್ಡರ್ ಮಾಡಿದಾನೆ? EPF. Yes. List on 27. Next.
Respondent number 2 doing the business of drawing the high tension electricity.
You are Saurabh.
I have a petition.
What's your name?
Pardon?
What's your name?
Saurabh.
It may be difficult for me to hear you. Yes. List tomorrow in the fresh matters list.
Please.
Notice 1, 2, all 4. Learned AGA is directed to accept notice for the respondent. Copy diya? Yes. Next. Parole.
Connector matter is dismissal.
Dismissed. It's not dismissed ಮಾಡಣ ಬಿಡಿ. The learned counsel for the ಯಾವುದು connected matter order
105032.
105032. The learned counsel for the petitioner submits that the connected co-accused, the parole that is sought co-accused has been dismissed. In that light, the learned counsel would submit that in that light, the same order would be to the petitioner as well. The coordinate bench of this court, while dismissing the petition, is held as follows. I will extract my order. Reject. Next. Covered page 20. Yes. The petitioner is before this court calling in seeking a direction by issuance of a writ in the nature of mandamus, seeking the following prior and the issue in the list need not detain this court for long or delve deep into the matter. DLV, delve deep into the matter. The coordinate bench of this court in annexure F, page 20, has held as follows. In the light of the issue already answered, petition disposed with the same directions. But directions matra, copy paste matra. With the same directions. Allowed. 21 is same. That's page number. Same order ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. ಇದರಲ್ಲಿ ಇರೋ ಆರ್ಡರ್ ಈಗ ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀನಿ. This is Alokar other flag ಹಾಕಿದ್ದೀನಿ. Next. Seizure of property. Muthoot Finance.
Yes, sir.
ಇಲ್ಲಿ ಯಾಕೆ ಬರಲ್ಲ ಮೇಡಮ್? ಪಾರ್ಟಿ ನಂಬರ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ ನಂಬರ್ ಅಲ್ಲಿ ಎಸ್ ಗೊತ್ತಾಯ್ತು ಏನು ವಿಲ್ ಸಿ 1 AGA 2 AGA accepts notice. Next, register to print the name of AGA as appearing to respond. Next, ಅಷ್ಟೇ ಎಂಟ್ರಿ ಮಾಡಲು ಕೊಡಕ್ಕಾಗಲ್ಲ ಅದು Interim order release ಮಾಡಕ್ ಹೇಳಕ್ಕಾಗಲ್ಲ. Let him come up with instructions.
What there is order of the principal court.
I know, yes. They will keep it in custody. Next week we'll post it and close it. List next list on 16th.
Challenge the compromise decree.
Why, sir?
My lord, the decree number 4 to 7, my lord, they are not given any share.
Petitioner
My
shall
lord,
serve on the.
I permit to withdraw the petition filed another petition.
Why?
Defend number 3, 4, 5, 6, 7 also filed.
Body. Learned counsel with the petitioner files a memo seeking to withdraw the subject writ petition, reserving liberty to file a fresh petition.
Please.
In the light of the memo, petition is disposed as withdrawn, reserving the aforesaid liberty. Next. Page 31.
This is challenge version, annexed C version.
Correct. Covered either. Page 31.
Already
Eradu.
proceedings.
Both 24 and 25. Madam, 24 and 25. Prayer court madi. Both the learned counsel appearing to the petitioner and the learned AGA would in unison, UNISON, unison submit that the issue in the list stands answered by the judgment of the coordinate bench. The coordinate bench is held as follows. Page 33, 34 extract madi, mark portion. Disposed. Yes. ನೀರಾವರಿ ನಿಗಮ ಯಾರ ಪೇರ ಎಸ್ ಎಜಿ ಅವರು KNN ನೀರಾವರಿ ನಿಗಮ ಗುಲಾಬ್ ಜಾಮೂನ್ ಲಿಸ್ಟ್ ಇಟ್ಕೊಳ್ಳಿ ಒಂದು ಯಾರ ಪೇರ ಯಾರು ಸರಿ ಸೊ ಹೇಳಿ petition accepts notice for all the respondents. Petitioner to serve set of papers upon the council, less the matter of 2 weeks. Next. Yavudu?
27 members.
Petition
to consider the representation.
Correct.
Because
Ready? Correct. How the interest on the arrears? Consider as representation. The petitioner is before this court seeking the following prayer. Quote the prayer. The petitioner heard so and so. The petitioner is said to have been appointed as assistant lecturer in the 4th Respondent College on 26/7/1967 and retires after completion of the age of superannuation. It transpires that the petitioner's pension was settled with enormous delay. The amount that was paid to the petitioner was 17,99,869. The petitioner submits a representation seeking, had filed a writ petition which comes to be allowed, directing the respondents to consider the representation within an outer limit of 3 months. That having erroneously considered, according to the learned counsel for the petitioner, has walked to the doors of this court yet again in the subject petition. The learned counsel for the learned HCGP would submit that if reasonable time is granted, the representation of the petitioner and for the purpose for which it is submitted would be considered and appropriate orders would be passed in accordance with law. In that light, without going into the merit of the claim of the petitioner or the defense of the state, I deem it appropriate to dispose the petition, directing the respondent to consider the representation of the petitioner and pass necessary orders in accordance with law within an outer limit of 12 weeks from the date of receipt of the copy of the order, if not earlier. Ordered accordingly. How are you challenging some MLA's order? Which MLA's order? Password. Same 26 ಅಲ್ಲಿ ಏನು ಮಾಡಿದೆ ಅದು ನೀವೆಲ್ಲಿದ್ರಿ 26 ಅಲ್ಲಿ?
On my election, I'm sorry.
ಸೇಮ್ 26 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ? ಕಮ್ಟೆ ಸರ್ 30 to 42 again 51 to 64 ಎಲ್ಲ ಟ್ಯಾಗ್ ಮಾಡಿ. It is wrong, I mean, court without jurisdiction. It's covered.
Covered.
But 8,000.
Covered, that was the problem for us. But 7 cases were filed out because of the sick one. 7 cases, a smaller amount or bigger amount was there. So we were not able to get the difference.
ಇದನ್ನೇನು ಮಾಡೋಣ ಈಗ?
But one thing that happened was the coordination with this on the court, another batch of petitions were there. And it is posted for dictation on 15/1.
On 15/1.
15/1.
All right.
I got the version of this one.
ಜಸ್ಟಿಸ್ ಹೇಮಂತ್ ಅವ್ರದ? ಸರಿ ಆಯ್ತು.
No, I can take notice also about all these cases.
You take notice, we will post it first week of February. Yes. Madam, ಎಲ್ಲ separate order ಮಾಡಲ್ಲ, ಟ್ಯಾಗ್ ಮಾಡಬಿಡಲ್ಲ ಎಲ್ಲ?
Tag ಮಾಡಬೇಕು. But cases are separate.
Cases are separate ಮಾಡಬಿಡಿ. Learned emergent notice to the respondent in all these cases. The learned counsel V.S. Kamte representing the petitioner HESCOM petitioner KPTCL in all these cases submits that the issue in the list stands answered by the judgment of the apex court in the case of so and so 1976 4 SCC page 634. In that light, there shall be an interim order of stay. He would further submit that all identical cases have been heard and are posted for dictating judgment on 15/1/2025. In that light, there shall be an interim order of stay of the order. ಕೇಳಿದಿರಾ ಇಲ್ವಾ? ಕೇಳಿದಿರಾ? ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ
ಅದು 30% ಫಂಡ್ ಮಾಡಿ ಹೇಳಿದ್ರು. ಸೊ this year what I was submitting to present note actually I will allow notice to respond so that not suppose not at least decided not by that time.
All right, we'll see. Covered by so and so ಅಂತ ಮಾಡಿ ಅಷ್ಟು ಅಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಮಾಡಿ ಮಾಡಿಬಿಟ್ಟು this petitioner is at liberty to serve on the respondents by way of hand summons. Second week of February. List the matter on 10th February. In the fresh matters list, we'll dispose it. Ashtal agidre. Next. Idu.
Number 26. There are other matters which are required to be clubbed as well.
Today
they are listed.
They are listed. Wait. Will our urgent talk baka? Yes. Idu. 30 in the 42. 50 in the 64. 51 in the 64. Same order. Yes. Right. They covered emergent notice to the respondent. The issue in the list stands covered by the judgment of the apex court in SLP 8412-8413 of 2023, disposed on 4/5/2023. Therefore, there shall be an interim order of stay of the as prayed for till the next date of hearing. Emergent notice to the respondent. Next. Kayak material. Dismiss ಮಾಡಿದೆ. ಏನು ಕೇಸ್ ಇಲ್ಲ. Dismissed. Yes. Next. Stay ಮಾಡಿದೆ. Cell number? Page 35 covered. Madam, writ appeal dispose ಆಗಿಲ್ಲ principal bench ಅಲ್ಲಿ. ಅಷ್ಟೇ. The petitioner is before this court seeking the following prayer. A coordinate bench of this court answering similar claim in a judgment reported in ILR 2015 Karnataka 5236 in the case of so and so has granted the benefit to similarly placed teacher. The operative portion of the order of the coordinate bench reads as follows. Page 125 to 127. The reported a copy paste marker. So, in the light of the issue, the learned CGP would submit that the writ appeal is preferred against the said order, which is pending consideration at the hands of the division bench. In that light, subject to the outcome of a writ appeal, I deem it appropriate to direct the petitioner to become entitled to the benefits in writ appeal 2476 of 2015 and connected cases. The petitioner shall be granted the said benefit with an outer limit of 3 months from the date of receipt of the copy of the order, which shall, however, remain subject to the writ appeal pending before the division bench. Yes, next. Reject ಮಾಡಿದ್ದೀರಾ? In the light of the issue standing answered by the coordinate bench, as also certain directions issued by the division bench in writ appeal 2416 of 2015, the petition deserves to succeed. For the aforesaid reasons, the following order allowed cost petition ಆಮೇಲೆ ಹೇಳಿದ್ನಲ್ಲ 3 months ಅಲ್ಲಿ ಕೊಡಕ್ಕೆ ಅಂತಲ್ಲ ಅದನ್ನು ಮಾಡಿ. However, it will remain subject to the result of the writ appeal. That is 47, 48, 49 ಒಂದೇ
45 67
ಒಂದು ನಿಮಿಷ ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್ ಇದ್ದ 45 ಸಾರಿ ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಂ ಸ್ಟೇಡ್ ಎಂಟ್ರಿ ಮಾಡೋದು ಕೇಳಿಲ್ವಾ tag this petition along with WP 105514 of 2024. The learned counsel submits that the coordinate bench has granted an interim order of stay in the aforesaid petition. The order reads as follows. Flag madam. Copy paste.
Notice my second.
Yeah, not
notice.
Yes, sir.
1, 2, 4, 5, 6 and 7 AGA.
1, 2, 4, 5,
6 and 7.
6 and 7 AGA.
3 and 8 Shashank Hegde.
Shashank?
Hegde.
3 and 8 Shashank Hegde. Yes. 46 to 49 same.
Same and also 107.
Yes.
And there is one more connected matter.
ಕೊಡಿ ಅದಲ್ಲ ಇದು ಸೌರಭ್ ಇದನ್ನ 26 ಅಲ್ಲಿ ಏನು ಮಾಡಿದೆ ಅದೇ ಆರ್ಡರ್ ಮಾಡಿ ಎಲ್ಲ ನಿಮಗೆ ಆಗ್ಬೋದು ಗೊತ್ತಿಲ್ಲ ಯಾರು ಬರ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ಕರೆಕ್ಟ್ ಏನು consider a petitioner is before this court seeking the following prayer heard so and so. The petitioner work allot madidra. The petitioner was awarded a contract on 6/3/2024 and after the completion 6/3/24, which was a short-term tender, the petitioner completes the work and submits a representation with regard to the actual amount he is entitled for on 7/6/2024. The petitioner complains of short payment and therefore is at the doors of this court seeking a direction for consideration of his representation dated 28/6/2024 for complete payment. The learned AGA would submit that if reasonable time is granted, the representation of the petitioner would be considered and necessary orders would be passed in accordance with law. In that light, I deem it appropriate to dispose the petition, directing the respondent state to consider the representation of the petitioner with an outer limit of 3 months in accordance with law. It is made clear that this court has not assessed the claim of the petitioner. Please, ordered accordingly. Subject to ಅಷ್ಟೇ 22 the order.
My lords, but since I was not served, my lords, only petition number 1, my lord, for a moment annexure came may be seen, my lords.
Not served.
Please, my lords, no unserved. Page number, my lord, annexure G, my lord, page number 36. The notice is issued on 28/4/2022, my lords. The notice dated.
Notice on whom?
Notice on respond number 1, my lords. Sorry, the petition number 1. That is sent to me, my lords. But it is dispatched on 7/5/2022.
Ashtal order ಆಗೋಗಿತ್ತಾ?
My lords?
ಅಷ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದು.
No, my lords. They say that they conducted the inquiry on 12/5. On my lords, on 28/6/2022, he conducts the inquiry and he submits the report. My lord, in the writ petition, the other petitioners were also party. We are not being given the notice. If I was not served, the other petitioners.
These petitioners allege that in the impugned proceedings, they were not heard, as no notice was served upon these petitioners. In the light of the said submission, there shall be an interim order of stay as prayed for till the next date of hearing. 1 AGA, 2 and 3 emergent notice.
Please, next.
My lord, in fact, the father of the petitioner was working in the respond corporation and he died.
When? Died when, sir?
Died in the year 2005.
15 years ಆದ್ಮೇಲೆ you want compassionate appointment.
My lord, his
Compassion ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ. Appointment ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
one submission is that your lordship may kindly see annexure E, where annexure E that submitted by the mother of the petitioner, where immediately within 1 year,
Maybe.
date of death, she submitted
Maybe.
representation.
Maybe.
And the moment when the petitioner attained the age of majority, he submitted representation
Maybe.
as per annexure F. My lord.
Compassionate appointment is to tide over the crisis that ensues a family, not after 15 years. Cash. ಇದು correct. ಇಲ್ಲ ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. Correct. Yes, sir.
My only submission is that, my lord, when he has attained the age of majority, he submitted representation. They should not have been considered.
ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ, ಇಟ್ಸ್ ಆಲ್ರೆಡಿ ರಿಜೆಕ್ಟ್. ಕಷ್ಟ. ಸಮ್ ಯಂಗ್ ಪರ್ಸನ್ ವಿಲ್ ಗೆಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್. 15 ವರ್ಷ ಆದ್ಮೇಲೆ ವೇರ್ ಇಸ್ ದಿ ಕಂಪ್ಯಾಷನ್? ಹೇಳ ದಿ petitioner ಅಷ್ಟೇ. The petitioner is before this court calling in question an endorsement dated 2/1/2024 passed by the respondent declining to accept the representation of the petitioner for appointment on compassionate grounds. Heard so and so. The father of the petitioner, who was, what was he working as? The father of the petitioner was an employee, working as a driver in the NWKRTC, Belagavi. He dies in harness, HRNES, harness on 7/10/2005. Within a year, the wife of the mother of the present petitioner submits a representation seeking appointment on compassionate grounds. The said representation is not considered. The petitioner then, after he attains the age of 18 years, submits a second representation on 5/9/2020, seeking appointment on compassionate grounds. The representation was not considered, which led the petitioner to submit yet another representation. An endorsement comes about on 2/1/2024, by which the claim of the petitioner comes to be rejected. The learned counsel appearing for the petitioner would vehemently contend that the representation of the petitioner ought to have been considered in accordance with law, as the petitioner has submitted his representation immediately on attaining the age of 18 years, and therefore submits that the endorsement should be quashed and a mandamus should be issued to the respondent to appoint the petitioner on compassionate grounds. The said submission is noted only to be rejected. Compassionate appointment is granted to a family who would lose their breadwinner to tide over the crisis that ensues the said ENSUS, ensues the said family on the death of the breadwinner. The death in the case at hand has happened in the year 2005. We are now in 2025. 20 years thereafter, no mandamus can be issued for consideration even of the appointment on compassionate grounds on the score that if the family was able to survive for 20 years without any appointment, the compassion having gone long ago, mandamus cannot follow. Therefore, the petition does not merit any consideration, and the same is rejected. Next. KDV. 45 same. Madam, 45 lane order ಮಾಡಿದ್ದೀನಿ. Yes. Next.
Daily wages employment.
Notice. ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗಲೂ? ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ರಿಟೈರ್ ಆಗಿದೆ.
Annexure G is the include order.
Anyway, 1, 2, 3. All state learned HCGP is directed to accept notice for the respondent. Copy idea, madam? Copy idea. Petition copy idea. Yes. List on 3 weeks bit on date code.
71 and 75.
ಯಾಕೆಲ್ಲ ಅರ್ಜೆಂಟ್ಲಿ ಇದೆ? Wait.
Serial number 71 and 75.
ಗೊತ್ತಾಯ್ತು, ಇರಿ. You want to go somewhere?
Please.
Wait. Dismissal. You are Prashant Usmani, na? ಇಲ್ಲ ಒಂದು ನಿಮಿಷ ಇದು ಯಾವುದು ಇಲ್ಲ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾನ್ಸ್. Yes, next. Compromise decree challenge. Petitioner to serve on the counsels who represented the respondent in the trial proceedings or by way of hand summons. The pendency of this petition does not alter the rights that are crystallized in favor of the respondents. Yes. Next. Same. ಯಾವ್ದಿದು? 68. Same order. 72 ನೋದಾ?
75.
Yes. Representation. Same emergent notice to the respondents. Next. Compassionate appointment.
As one of the petitioner was working as an office assistant in the respondent number 2. But during his service, he died. So the
Karnataka Gramina Bank.
Gramina Bank.
ಯಾವ date of death?
Date of death was Annexure A minus.
Annexure A is the data.
15/6/2014.
ಅದೇ date of death and Annexure A ಅಂದ್ರೆ 15/6/2014
months. But subsequently the petitioner filed give the representation before the respondent number 2 authority within 1 year months.
That's all. 10 ವರ್ಷ petition ಹಾಕಿರೋ 24 ಅಲ್ಲಿ.
But endorsement as issued by the
24.
authority 24.
Emergent notice to the respondents. Petitioner is at liberty to serve on the counsel who represents Karnataka Gramina Bank. Put up immediately after service of notice. Next.
Petitioner is a soldier. Petitioner is a soldier seeking mandamus.
Interim order ಏನು?
Seeking mandamus to consider my representation.
ಗೊತ್ತಾಯ್ತು? ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಲಾ?
The land is available or not,
In accordance with law.
Please.
Petitioner,
Even though if the land is not available, there is a section, as per section 71 of the Land Revenue Act, the.
I will record that submission.
Yes. As per Annexure C and D.
The petitioner is before this court seeking the following prayer. The learned counsel heard words. The counsel for the petitioner submits that the petitioner, who is an ex-serviceman, ex-serviceman serving in the Indian Army, as so and so, with synopsis, first synopsis, submits a representation on 16/2/2016 to the authorities for grant of land as is available under the statute to the ex-serviceman. The said representation did not merit consideration, and it is therefore the petitioner is at the doors of this court. The learned counsel appearing for the learned AGA on verification of records would submit that the land is not available to be granted to the petitioner. The learned counsel for the petitioner submits that even if the land is not available in terms of section 70 and 71 of the Karnataka Land Revenue Act, Land Revenue Act, the petitioner is entitled to a land, which he has submitted in his representations. Representations dated 27/6/2023. Representation dated 27/6/2023. The learned AGA would submit that representation would be considered in accordance with law and appropriate orders would be passed. In the light of the said submission and contra submission, I deem it appropriate to dispose the petition, directing the state to consider the representation of the petitioner for the purpose for which it is submitted in accordance with law, within an outer limit of 3 months from the date of receipt of the copy of the order, if not earlier. It is made clear that this court has not assessed the merit of the claim of the petitioner, ordered accordingly.
Yes, he is a soldier, since it is a typographical name.
In typographical?
Allah, now ex-serviceman anta barutide.
Soldier ex-serviceman alva?
Allah, he is serving.
He is in service still. Then how are you entitled to the land?
Allah, within the retirement age, he has to.
Correction.
Please.
ನೀವೇ ಎಕ್ಸ್-ಸರ್ವಿಸ್ಮನ್ ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀರಾ ಇಲ್ಲಿ? Yes. Same. 60? 68 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್? ಕಂಪ್ಯಾಷನೇಟ್
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಇರ್ಲಿ ಬಿಡಿ, 6 ಅಂತ ಹೇಳಿದ್ದೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇ, ಏನ್ ಬೇಡ ಚೇಂಜಸ್. Are you dispossessed or not? Learned AGA is directed. Reconstruction, rehabilitation, emergent notice to respondents 1 and 2. ನೀವೇನ ಅದಕ್ಕೆ? ನೀವೇನ ಎಲ್ಲರಿಗೂ? Learned AGA accepts notice for all the respondents. The petitioners shall not be dispossessed if not already dispossessed as on today. Next. Notice. Madam, sir. Close madla. Where is it? All right. Then learned AGA, learned HCGP is directed to accept notice for respondent. DODC ನೀವೇ ಅಲ್ವಾ? District Urban Development Cell. Yes. To the respondents. Yes. Yes. 2 weeks, 3 weeks put on it. Next. ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ? ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ಮತ್ತೆ ಹೌ ಕ್ಯಾನ್ ಯು ಡು? ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಮ್ಯಾಂಡಮಸ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ? ಯು ಶುಡ್ ಚಾಲೆಂಜ್ ದಟ್ ಸರ್. ಅರೆ ಯು ಶುಡ್ ಚಾಲೆಂಜ್ ದಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್. ಇನ್ ದಿ ಟೀತ್ ಆಫ್ ದಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ವೇರ್ ಕ್ಯಾನ್ ಅ ಮ್ಯಾಂಡಮಸ್ ಲೈ? ಮಾಡ್ತೀರಾ? ಫ್ರೆಶ್ ಪಿಟಿಷನ್ ಹಾಕ್ತೀರಾ? ನಿಮ್ಗೆ ಏನ್ ಬೇಕು? ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್. ಆಲ್ ರೈಟ್. Learned ಹಿಂಗೆ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The learned HCGP and instructions would, HCGP would submit that an endorsement rejecting the claim of the petitioner is already, it's already issued, the learned counsel submits that he would amend the petition by raising a challenge to the said endorsement. Needful be done in the next 2 weeks. Next. ಇದು compromise decree. ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ?
No, the recent.
Recent.
I'm not a party.
What is the fraud here, sir?
Dated 16.
What is the fraud here?
No, respondent number 1 is a plaintiff before the trial court. Respondent number 2 is the defendant. The suit is for recovery of money between those two persons. They got compromised on my property. It's a joint property,
One,
not a party.
the petitioner shall serve on the counsels who represented the respondent in the trial proceedings or by way of hand summons to the respondents themselves and file an acknowledgement to that effect.
We have grown sugar cane, we are interfering. By virtue of that,
Injunction ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಇಲ್ಲಿ? Seeking injunction?
I'm seeking not the stay of that order.
There shall be an interim order stay of further proceedings taken to the impugned proceedings. Next. 16/3/20. Further proceedings taken to the impugned proceedings dated 16/3/2024. Next. Objections. File your objections. ಬೇಕಾಗುತ್ತೆ. Learned counsel Sangram Kulkarni seeks 10 days time to file statement of objections. Objections, if any, by the next date, list on 23rd January. Yes.
Then further postings in
And further proceedings.
The application has been filed to accept the change report, wherein the managing committee has been appointed. This application was filed in the year 2018. In the year 2024, they filed an application.
Objection, Aki. Yes.
Still less that.
No, till then. Yes, next. Emergent notice to the respondent. EPF ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ? ವಿಮ್ಸ್. ನೀವು ಪೆಟಿಷನರ್ಗೆ ಸರ್, ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ರಾವಿಡೆಂಟ್ ಫಂಡ್ ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ? ಇದಾರ ಯಾರು ಮೇಡಮ್? Learned counsel so and so accepts notice for the respondent. There shall be an interim order of stay as prayed for till the next date of hearing. Next. Cancellation of registration. Interim order ಎಲ್ಲ ನೀವೇ ತಗೊಂತೀರಾ? Learned AGA is directed to accept notice for respondents 1 and 2. Copy ಇದೆಯಾ?
Copy.
Yes. List on 24th. Yes. Yes, sir, the lighter job. You've already been given twice.
Twice has been.
Then you want lighter job all your life. Disability is not cured.
Here, the problem is that the form in which the certificate is issued is under the repealed act.
Under the
repealed act.
Sir, all right. We will get a form in that only. In the present act, disability vanishes. Is it repealed act?
No, it doesn't vanish. But my lord, these are, as far as these certificates are concerned, medical certificates are concerned.
I know.
Less said the
less said the better. How they are generated, we know. That's a different
Therefore,
thing.
my lord, there are few judgments of this honorable court, wherein my lord, in similarly situated cases, the courts have specifically directed my lord, the medical board to issue certificates in the prescribed format, so that the layman can understand what is the.
ಈಗ ಯಾವ ಫಾರ್ಮ್ಯಾಟ್ ಅಲ್ಲಿ ಇದೆ ಸರ್?
That is under the old.
ಈಗ ಹೊಸ ಫಾರ್ಮ್ಯಾಟ್ ಅಲ್ಲಿ ತಗೊಂಬನ್ನಿ. ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ಆಕ್ಟೆಡ್ ಅಪಾನ್ ಮುಂಚೆ.
In the similar cases, my lord, this court has.
ಎಸ್ ಪ್ರಶಾಂತ್. ಕ್ಲೋಸ್ ಮಾಡೋಣ.
There is my lord.
ಕಮಲ್, ಜಸ್ಟಿಸ್ ಕಮಲ್ ಅವರು.
There is my lord, another judgment, my lord, by Justice Kamal, where my lords have taken note of the fact that these certificates are issued under the old act. Therefore, my lord, the corporation is directed to give another my lord requisition to the medical board, which my lord may pass on.
ಆಯ್ತು. ಕಾಂಟ್ರಾ ರಿವ್ಯೂ
ಅವ್ರದ್ದೇ. After my lord going through all.
The 3rd June or the 12th June, mostly enlightened the court. Yes. ಇದರಲ್ಲಿ ಏನು ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ರೆಫರ್ಡ್ ಟು, this court has directed them to continue the lighter job till the expiry of the period where the
ಈಗ ಎಷ್ಟು ಪೀರಿಯಡ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಲೈಟರ್ ಜಾಬ್?
Lots.
ಒಂದು ವರ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ.
Twice, my lords, 1 year, 1 year. 2 years, my lords. The story.
No, see, I'll tell you, these are technicalities.
Please.
If he is unable to perform the job that is allotted to, and you have acted upon those the disability of the petitioner twice, rule or no rule, or new rule or old rule, disability does not vanish.
Now, Lord, what my suggestion is this, that we'll continue with the law, but let him be subjected to the medical examination.
That I will direct.
That direction, my lord.
That is what the Lord is.
ಆಯ್ತು, ರಿಮೈನಿಂಗ್ ಪೀರಿಯಡ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ, then subject ಅಲ್ಲ, immediately they will be subjected to medical board under the new act.
The view taken by this court was in similar circumstances. Till the expiry of the period, reassessment was directed by the medical board. He shall continue.
Yes, Prashant.
And he shall be referred to the medical
If
board.
this is to be followed, we'll follow it.
We will, my lords, continue him. But in the meanwhile, Lord, let him be subjected to the examination, and
Yeah.
depending upon, my lords, the.
That is what this court has held.
Please.
Which judgment? First 3rd June or 12th June?
12th.
Your ಪ್ರಕಾರ 3rd June.
Thereafter,
This is a later judgment. We will follow this.
Orders were passed. Then, my lords, this judgment, wherein, my lords, detailed.
Yes, detailed analysis is here.
Take a note of, my lords, the forms that are available in the act. In fact, the government has also, my lords, passed an.
Yes, Ravi.
Circular.
Will dispose it following the later judgment. ಅದರಲ್ಲೂ ಅದೇ ಹೇಳಿರೋದು. You will be continued in the lighter post, but you will be subjected to medical board.
Yes, that can be done.
Same order, sir.
Sometimes my Lord they refuse. Now my Lord.
That he is accepting, sir. He is accepting that you will be continued in the same post, and you will be subject to the medical board, and all proceedings further will be subject to the outcome of the medical board.
Yes. Agreed.
ಅದೇ ಮಾಡಿರೋದಿಲ್ಲ.
You will follow this Lord where I have relied upon. My friend has argued.
ಅದು ಅರ್ಲಿಯರ್ ಜಡ್ಜ್ಮೆಂಟ್, ಇದು ಲೇಟರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅವ್ರದೇನೆ.
But will the expiry of the period mentioned by referring to the rule, my Lord, Rule 18. This court has held that till completion of that period, reassessment is ordered to be done by the medical board. Till such that he shall be continued.
Oh.
And again he shall be subjected for medical board.
He is not denying that at all. Same, ಇದು ನೋಡಿಲ್ವಾ ನೀವು?
ನೋಡಿದ್ದೀವಿ.
ನೋಡಿದಿರಲ್ವಾ?
My friend had appeared, my lords.
ಪ್ಯಾರಾಸ್ ಅದು ಇವ್ರದೇನಾ?
ಹೌದು.
ಇಲ್ಲ, ವಿನಯ್ ಕುಮಾರ್ ಭಟ್ ಅಲ್ಲ ಇದು? ನೀವೇ ಅಪಿಯರ್ ಆಗಿ. ಹಾಗಾದ್ರೆ we'll follow this and close it. The petitioner is before this court seeking the following prayer. The learned counsel Ravi Hegde, appearing to the petitioner, submits that the issue in the list stands answered by the judgment of the coordinate bench in writ petition 103069 of 2024, dated 3rd June 2024. The coordinate bench had held as follows. Quote the order from para 9 till the end. A week thereafter, the very same coordinate bench, after elaborate consideration of the act and the manner in which the certificate should be issued, manner and the form in which the certificate should be issued, has held as follows. Now, para 10 in the end. In the light of the aforesaid orders passed by the coordinate bench in the aforesaid cases, the petition, I deem it appropriate to dispose the petition, granting the petitioner the very same benefit that the coordinate bench has granted to a similarly situated employee of NWKRTC. The petition is thus disposed on the same terms.
It shall be.
Same terms in writ petition 102082, which has directed that the petitioner shall be continued in the lighter post and be subjected to medical board, and all further benefits would flow from the outcome of the medical board's examination. Yes, ordered accordingly.
69 and 72, I am sorry, my Lord, I was in other court.
Notice ಮಾಡಿದ್ದೀನಿ, ಹಿಂಗೆ ನೋಟಿಸ್ ಬಿಟ್ಟೇನಿಲ್ಲ.
Sorry, my Lord.
No problem. Yes. Mandamus Panchatantra.
Mandamus is against Withdrawal No. 6 here.
ಆಯ್ತು 1 to 5 ಅಲ್ಲ 5 ಅಲ್ಲ 1 and 2 HCGP, 3 to 6 emergent notice. Returnable ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದರಲ್ಲಿ? ಕರೆಕ್ಟ್ ಸರ್, ಎಂಟ್ರಿ ಮಾಡಲ್ ಸ್ಯಾಲರಿ ರಿಲೀಸ್ ಮಾಡಕ್ ಹೇಳದ. Permit the petitioner to work ಅಂತಿದೆ. The respondents wait, we'll give a date. Serve ಮಾಡಿ ಇವತ್ತೆ. The respondents 3 to 6 shall explain as to why the petitioner is neither given work nor paid salary for the work that is already performed. The explanation be tendered by the next date, list on 20th in the fresh matters list. Next. Refund of differential GST. Allah, it's covered, sir. Page 25.
21/11 representation.
21/11. 2 months I covered already.
4 days.
Yes. Why are you so early? ಒಂದು ಸ್ವಲ್ಪ ದಿನ ವೇಟ್ ಮಾಡಬಹುದು.
2 days.
Next Monday in the fresh Monday ಬೇಡ. Next Wednesday at fresh matters list. Yes, next. Salary grant.
Was being rejected.
Huh?
Was being rejected.
1, 2, 1 to 3 HCGP, 4 emergent notice. Yes. Page 29.
Principal bench has not disposed of the similar.
Same. Regularization claim. How can they be party to the order, madam? What is this? How can they be party to the order? The petitioners, who are a few of them who have retired and a few of them serving in the Department of Horticulture, are knocking at the doors of this court, seeking a direction by issuance of a writ in the nature of mandamus to regularize their services in terms of the order passed by the coordinate bench in so and so, page 29 alide madam. The learned counsel for the petitioner submits that the petitioners are also similarly situated as few of the petitioners in the decision rendered by the coordinate bench were all their colleagues. In the light of the coordinate bench has on elaborate discussion allowed those petitions by quashing the endorsements and directing consideration of their cases for regularization as held as follows, page 79 to 80. In the light of the petitioners similarly situated and are seeking the same benefit as that of those in the writ petition, in the order in the writ petition passed by the coordinate bench, I deem it appropriate to direct the respondent to consider the representation of the petitioners strictly in consonance with what the coordinate bench has held as afore quoted, within an outer limit of the outer limit of 3 months from the date of receipt of the copy of the order, if not earlier, ordered accordingly. Appoint ಆಗೋಗಿದೆಯಲ್ಲ ಅಂಗನವಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವ್ರಿಗೂ. ಏನ್ ಮೆಮೊ ಮೇಡಮ್?
Your Lordship, some of the applicants are not completed with the process of application.
Some of the applicants.
And one of them is the petitioner also.
All right.
Now, the government has taken decision to make the applications, update the applications of this Lordship.
ಅದರಲ್ಲಿ ಕನೆಕ್ಷನ್ ಸಿ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 1 is selected
ಸೆಲೆಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
They have filed fresh applications here, and we have accepted it. Since the provisional list is not valid, henceforth we
As per which you challenge madam provisional list. Correct? Now the HCGP says that they have permitted application, they have called, permitted those applicants to file applications now. Provisional list goes, I will record that, you also file your application.
Fresh application.
Fresh application, correct?
Please.
You also file a fresh application, all contentions will be left open. Yes. The petitioner is before this court.
Next SC may be questioned.
No, why sir? It has become redundant. I will record that. The petitioner is before this court. Nim client ಹೇಳಕ್ ಮಾತ್ರ ಕಾಸ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವರೇ ಹೇಳಾಯ್ತದೆ. The petitioner is before this court calling in question a notification dated 17/8/2024 which selects the third respondent provisionally to the post of Anganwadi worker. The learned HCGP files a memo appending certain documents to submit that the state on 23/12/2024 has issued a notice to applicants to submit fresh application. Therefore, the provisional select list is superseded by the said notification and has lost its efficacy. The learned HCGP would further submit that the petitioner has also submitted a fresh application in terms of the notice dated 23/12/2024. In that light, nothing further would survive in the subject petition. However, all contentions that are urged in the petition shall remain open, ordered accordingly.
Third respondent, fifth respondent.
Fifth respondent. ನೀವೇ 3 ಅಂತ ಹಾಕಿರೋದು. ನಿಮ್ದೇ ತಪ್ಪು. Yes. Next. 80?
Petitioner company has installed the telecommunication government.
Police protection ಯಾಕೆ?
Since the neighbors are causing unnecessary obstruction,
Who is
threat of demolition also.
ಅದಕ್ಕೆ
And we have made a
civil suit
declaration, filed a complaint also.
File a civil suit.
Well, a complaint is also filed as per annexure F.
I will take notice. Learned AGA is directed to accept notice for the respondent. All respondents. Yes. Next.
May I request you?
First week February.
No, since every day they are causing nuisance.
Who is causing?
The
State is causing.
Neighbors. I'm seeking only a direction.
The learned AGA to secure instructions with regard to the grievance of the petitioner and submit on the next date, 20th, in the fresh matters list. Yes. Innu early na? Yes. 16th.
Please.
Yes.
Short point for consideration.
ಏನ್ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಸಸ್ಪೆನ್ಷನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಇರ್ಬೇಕಾ ಬೇಡವಾ ಅಷ್ಟೇ.
Only grievance is about now by virtue of I will face inquiry, my lord, there is no difficulty.
The inquiry we are not staying at all.
Then, my lord, there is no, my lord.
Yaar Prashant Usmani, serve on him. A petitioner shall serve requisite set of papers upon Prashant Usmani representing the respondent. List day after tomorrow in the fresh matters list. Learned AGA is directed to accept notice for 1 to 3 and 1 to 3 and 5. Emergent notice to the 4 and 6. Interim order ಇಲ್ವಲ್ಲ? All right. ಅಲ್ಲ ವಾಷಿಂಗ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದೀರಾ? ಇದು provisional select list. Anyway, getting day after tomorrow in the fresh matters list. Yes. ಇಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಕೊಡ್ಲಿ, ಪಾಸ್ವರ್ಡ್ ಬೇಕಾ? ಆಯ್ತು ಪಾಸ್ವರ್ಡ್ ನಾನು ಮಧ್ಯಾಹ್ನ ಕೆಲಸ ಇಲ್ಲ. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಒನ್.
Petitioners are the trustees.
Very good.
Nowhere concern my lord some third person.
Third person.
Vijay,
I am
devotee
filing-
claims to be a devotee, he wants to interfere in all kinds of petitions, my lord. My lord, he is nowhere concerned or spouse any expose. This is the
I am a
order.
member of the petitioner Devasthan committee, Your Lordship. I intend to file impleading application. Yesterday I received.
Intending, file.
Impleading, Your Lordship.
Intending to file.
It is ready, Your Lordship.
File
Since
it.
it could not have come before this honorable court, had I filed it in the counter today,
Ah.
I have it now, Your Lordship. It may be kindly be taken up on tomorrow's board or day after tomorrow's board.
Who are you?
I am a member of the petitioner Devasthan committee, Your Lordship.
What is your grievance?
My grievance is, Your Lordship, without my approval, in the sense, in the
Your
meeting-
approval?
No, Your Lordship, my consent.
You are concerned, why?
Please, Your Lordship, as I am a member of the petitioner committee,
Ah.
even behind my back, there have been some unlawful activities. For reasons known to the petitioner, criminal actions have been initiated against not only the committee, including me, the criminal actions have been initiated. And a writ petition was also filed before this honorable court, questioning the appointment of administrator, wherein liberty was granted to the present petitioners, Your Lordship, to implead myself in the appeal proceedings before the
All right, you
Dharwad
file.
Commission.
Now what is the problem? 7/11/24 order.
Yes, your lordship, the earlier my lords may kindly see, this honorable, all these matters started when the compromise was entered before this honorable court between the earlier tenants and the trust committee, my lord. It was registered under the repeal BPT Act, my lord, and in the year 2000, my lord, the application which filed under the Karnataka Enhanced Abolition Act, my lord, both this petitioner and the respondent, the matter was remanded, where we were granted, my lord, the land to the extent of 62 acres, my lord. And this, my lord, land,
Let
it
him
was
file.
barren itself, my lord.
What is to maintain status quo till the next date of
My lord, now, kindly see this order annexure which we have got settlement before this honorable court.
that time, that's page 110.
Yes,
Ah.
109, my lord, it says, order of this honorable court. This they have challenged in a third person, saying that devotee, they have never visited that temple also.
See.
And now, my lord, by virtue of.
I'll take it day after tomorrow. List day after tomorrow. Parties to maintain status quo to the next date of hearing. Yes, next.
Yes.
Nadit. Yes, next.
Your Lordship, against the respondent number 2, that is CEO Jilla Panchayat, wherein there was a vacancies in the library post of several villages of coming under the
Jilla Panchayat Uralla.
of. Your Lordship, I was
One HCGP, Jilla Panchayat Bagalkote ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ? Jilla Panchayat Bagalkote. Emergent notice to the second respondent. Returnable by 27th. Yes. Taking steps. 15 ವರ್ಷ ಆಗಿದೆ. What taking steps? We will dismiss it straight away. What unserved, sir? Yeah, what is the matter? Waqf board is before the court challenging what? Of the tribunal. Nim tribunal nimmel bardha. I will not interfere. We will not retain this 15-year-old cases in the steps. Only if you have challenged only the order against continuation of delay. But the merits then.
On the merits it can be challenged that LR charges were brought on my part, there was a delay, and for consideration of delay, notices have been issued.
No problem. You make out a case. You make out a case on merits. We will allow. If you allow ಮಾಡಾಗಿದ್ರೆ ಮಾತ್ರ I will issue notice. Dismiss ಮಾಡಾಗಿದ್ರೆ ಬೇಕಾಗಿಲ್ಲ. 2010 matter. Come day after tomorrow at 2:30. No, sir. You make out a case on merits. ನಿಮ್ದು ಏನಿದೆ ಹೇಳಿ. ಆಮೇಲೆ ನೋಡೋಣ notice. If it is to be dismissed, no notice need be issued. You are the Waqf board. You lost your case before the tribunal, and for 15 years it is languishing for notice. No, you make out a case on merit, then we will see. List day after tomorrow at 2:30 p.m. Yes, next.
case, the petitioner is challenging the,
What order, sir? What order you are challenging?
in this case, the petitioner has an application for stay of suit, Your Worship. This is what happens earlier, the respondent has filed suit for declaration, Your Worship. Subsequently, with the same relationship, he has filed one more suit in public court. There, Your Worship, the petitioner wife has filed an application under section 10 of CPC for stay of the subsequent suit. The stayed application came to be dismissed. Against that, Your Worship, the petitioner.
What happened to the earlier suit?
Earlier suit is pending in the state case. The
Yeah,
maintenance order was ordered.
Why two
ಎರಡು
suits?
suit ಫೈಲ್ ಮಾಡಿದ್ದೀರಿ
Why?
ಅದೇ ಡ್ಯೂ ಟು ಮಿಸ್ಗೈಡೆನ್ಸ್ ಅಡ್ವೊಕೇಟ್ ಸರ್
One suit ಮಾತ್ರ ನಡೆಯಕ್ಕೆ ಸಾಧ್ಯ.
ಅದು ಹುಬ್ಳಿಯಲ್ಲಿ ನಾನು ಎಂಡ್ ಆಫ್ ದಿ ಕೇಸ್ ಕಂಡಕ್ಟರ್ ಆಗಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದೀನಿ ಸರ್
ಯಾವ ಸೂಟ್ ಬೇಕು ನಿಮ್ಗೆ?
ನಾವು ಹುಬ್ಳಿ ಸೂಟ್ ಬೇಕು
ಹುಬ್ಳಿ
ಲೋಕಲ್ ಅಲ್ಲೇ ನಾವು ವರ್ಕ್ ಮಾಡೋದು ಸರ್
So what happened? In the earlier suit, the maintenance order was passed. Subsequently, with the same day, the same ground. For his convenience and he filed a suit.
What is the amount of maintenance granted?
5,000 per month ಸರ್
Arrears ಎಷ್ಟಿದೆ? ಎಷ್ಟು ಕೊಡ್ಬೇಕು arrears?
ಅರಿಯರ್ಸ್ ಒಂದು 70,000 ಬೇಕು
ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ಯಾವಾಗ?
DNA ಟೆಸ್ಟ್ ಹಾಕೊಂಡಿದ್ದೀವಿ ಸರ್ ಅದು
DNA?
DNA ಟೆಸ್ಟ್
Why, sir?
The second petition is not want to me sir. ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಸರ್ ಅದ್ರ ಸಂಬಂಧ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಸರ್ ನಾನು ಅದು ನಮ್ಗೆ ಮಿಸ್ಗೈಡ್ ಮಾಡಿ ಇನ್ನೊಬ್ರು ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಿ ಹಾಕಿದ್ರು ಸರ್ ಹುಬ್ಳಿಯಲ್ಲಿ ಅದೇ ಡಬಲ್ ಸೂಟ್ ಆಗಿದೆ ನಾನು ಮಿಸ್ಗೈಡೆನ್ಸ್ ಮಾಡಿದ್ದೆ.
How old is the daughter? ಸನ್ ಎಷ್ಟು? ವಯಸ್ಸು ಎಷ್ಟು?
ಏಜ್ 18 ಇಯರ್ಸ್ ಅಟೆಂಡ್ ಮೆಜಾರಿಟಿ ಏಜ್ ಸರ್ ಇನ್ನು 3 ತಿಂಗಳು ಮೆಜಾರಿಟಿ ಏಜ್ ಕೊಡ್ತಾನೆ.
ಇನ್ನು 3 ತಿಂಗಳು ಇದೆಯಲ್ಲ, ಅಷ್ಟರಲ್ಲಿ ಅರಿಯರ್ಸ್ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. DNA ಆಮೇಲೆ ನೋಡೋಣ.
DNA
ನೋ, ಫಸ್ಟ್ ಅರಿಯರ್ಸ್ ಆಮೇಲೆ DNA. When do you pay? ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರಿ?
ಎಂಡ್ ಆಫ್ ದಿ ಕೇರ್ ಕಂಡಕ್ಟರ್ ಆಸ್ ಎ ಕಂಡಕ್ಟರ್.
We will direct attachment of salary ಕೊಡದೆ ಹೋದ್ರೆ. ಯಾವಾಗ? 2 weeks ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಡೆಪಾಸಿಟ್ ಸರ್ಟನ್ ಅಮೌಂಟ್. ಅಲ್ಲ ಅವ್ರ ಕೇಸಲ್ಲಿ ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅದು ಪೆಟಿಷನ್ ನಂಬರ್ 2
ಅದು ಆಮೇಲೆ ವಿಲ್ ಸಿ. DNA ಲೇಟರ್, ಫಸ್ಟ್ ಯು ಪೇ. ಅರಿಯರ್ಸ್ 50% ಆಫ್ ದಿ ಅರಿಯರ್ಸ್ ಪೇ ಮಾಡ್ತೀರಾ?
ಪ್ರತಿ ತಿಂಗಳನ್ನು ಇದ್ರಾಗ ಕೊಡ್ತಾ ಇದ್ದೇನೆ ಸರ್. ಆಮೇಲೆ ಪ್ರತಿ ತಿಂಗಳ ರೇಟ್ಗಳು ಕೊಡ್ತಾ ಇದ್ದೇನೆ ಸರ್ ಮೇಂಟೆನೆನ್ಸ್ ಪರ್ ಮಂತ್ 5,000 ಸರ್. ಆಮೇಲೆ ಇದು ಡಿಕ್ಲೇರೇಷನ್ ಫಾರ್ ಪೇಟೆಂಟ್ ಆಫ್ ಚೈಲ್ಡ್
ಎರಡೆರಡು ಸೂಟ್ ಯು ಕಾಂಟ್ ಆನ್ ದಿ ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್.
ಆಮೇಲೆ ಡಿವೋರ್ಸ್
ಅದೆಲ್ಲ ಇರಲಿ. ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ ಕೇಳ್ಕೊಂಬನ್ನಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ. Interim order ಇದೆಯಾ? Interim order subsisting shall continue to the next date. Reporting the death of so and so.
An order has been passed on the memo reporting death.
Secretary will post it in B group. There is already an order.
Order is there. And there is one more order by this order report in the connected petition. That the matters are deferred, silent time till the adjournment, till the disposal of the matter before the Honorable Apex Court. Concerning the same issue.
What's the issue? What's the issue?
Yes. In this matter, the first matter of 2022, I have filed my statement of objections, page number 33 may kindly be taken.
No, not in this stage. We'll post it in B group.
Yes.
This court on 11/11/2024 had directed the matter to be listed in B group. Therefore, list the matter in B group on next Wednesday, 16th. Yes, 16th Thursday. Next. Council submission. Office objections overruled. List on Wednesday in the fresh matters. Next. Withdraw. Learned counsel with the petitioner submits that the petitioner, liberty veka. Petitioner does not wish to pursue the matter any further. The submission is placed on record. Petitioner is disposed as withdrawn. Next. Office objections overruled. List the matter on Wednesday in the fresh matters list. Same order.
Verified.
Learned counsel seeks a week's time to comply with the office objections. List the matter only after compliance with the office objections. Next. 101. Same order. Yes. Same order. Office objections overruled, list the matter on day after tomorrow in the fresh matters. Same order. Day after tomorrow. Same order. ಅದು ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಹಾಕಿ ಅದು ಸೇಮ್ ಆರ್ಡರ್. Overruled Monday, sorry, Wednesday. Office of, a week's time is granted. Tumba is objections. KT, why for it? Provisional. List tomorrow in the fresh matters list. Next. Office objections overruled day after tomorrow in the fresh matters list. One vara. 1 week.
Appeal provision notice, 75 notice.
Appeal provision. Learned counsel for the petitioner submits.
I know merit.
ಹಂಗೆ ಹೇಳಿದ್ರೆ ಬರಿಬೇಕಲ್ಲ ನಾವು. ಅಪೀಲ್ ಇದೆಯಾ?
Appeal section 75 notice. Insolvency Act.
Insolvency Act.
Yes.
Will permit you to file an appeal if you have a remedy.
No merit.
Dismissed.
Yes.
ಮಾಮೂಲಿ ಹೇಳ್ತೀನಿ. Non-filing of acknowledgement. Learned counsel. Learned counsel so and so. ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? Learned counsel so and so submits that he has entered appearance for the respondent. Registry to print the name of so and so is appearing for the respondent. 2 weeks time is granted to file objections, if any. No representation on behalf of the petitioner. List the matter on 20th. Next. Overruled. Wednesday, fresh matters. Next.
I filed power this morning, Manoj, on behalf of the respondent.
Learned counsel Shivraj Mallalli submits that he has entered appearance for the respondent.
Sole respondent.
FCL respondent. Registry to print the name of Shivraj Mallalli as appearing for the respondent. Thus completes the service of notice. List the matter in preliminary hearing.
Please.
Preliminary hearing on 20th.
Please.
Non-compliance. A week's time is granted to comply with the office objections. Next.
I agree, my lord, but ಇದರಲ್ಲಿ ಏನಪ್ಪ ಅಂದ್ರೆ not efficacious because
Not efficacious.
increment order is passed.
Not efficacious revisional remedy. Appeal statutory remedy.
Statutorily 106 there is a provision, my lord. But based on without giving opportunity, the increment order is
Let
passed.
me see. List tomorrow in the fresh matters. Yes. Password. 2012.
For the respondent,
Dismissal matter or criminal acquittal ಆಗಿದೆ. So there are some technical issues or senior counsel engaged in this matter. It's coming on 9.
Let's the CBI case was registered against the petitioner hearing.
CBI.
Please, Manoj.
Acquittal ಆಗಿದೆಯಾ?
Acquittal. Recently, it has been acquittal, and thereafter the matter has been. I have been implicated as a respondent number 3.
Who are you?
Lords, I am the managing director of the Union Bank.
Acquittal has become final?
No, my lords, it has to be ascertained because of the changes of the regional offices and all other things, my lords. I am unable to secure the correct instructions in this regard. So I kindly request.
I'll grant you, it's 2012 matter.
Please,
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ. I'll post this on 16th. 10 ದಿನ.
Please, my lords.
At the request of the learned counsel, Girisha,
Please, Girish, please.
One submission. My request on 9th, signature is coming, let him make submission. Later Lordship can, if my brother wants time on that day, because we
Australia, you gather whatever information you want. List on 9th at the request of ML Vanti, appearing for the petitioner. Yes. 9th in preliminary hearing. Yes. Shashank. Sit down 16th. List on 16th, 119, 120. So what?
in that there is a factor, the finding that the marriage has not been proved. And that
Marriage agilva.
and it claiming to be the wife, he initiated all that was even 375.
ಇನ್ನು ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಏನಾಗ್ತದೆ? ಆಗ್ದೇನೆ 10 proceedings.
After 6 years, the finding by this and which has been challenged and confirmed by this one. Even
Finding is that there is no marriage.
no, in the petition filed by her.
Who appears for the respondent? Appear ಆಗಿದಾರ? Party in person, sir. Correct, ಅದಕ್ಕೇನು ಜಡ್ಮೆಂಟೇ ಬೇಕಾಗಿತ್ತು. will one chance ಕೊಡೋಣ. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇನು ಹಾಕಿದ್ದಾರೆ, ನೋಟಿಸ್ ಏನಾಗಿರುತ್ತೆ? List them, heard the learned counsel Prashant Gowder appearing to the petitioner. There is the respondent in person is absent, awaiting her appearance as a last chance. List this matter on 21st. Yes. Interim order subsisting shall continue till the disposal of the petition. Vacating stay.
Caste certificate.
ಎಲ್ಲಿದ್ದಾರೆ? ಆರ್ ಸಿ ಹೆಗಡೆ. Interim order ಇದೆಯಾ?
Interim order.
There is no representation by of the petitioner awaiting his appearance. List the matter on 21st as a last chance. In the event there would be no appearance, the matter would be heard and disposed. The respondent counsel would be heard and the matter would be disposed. Next. Subject to the aforesaid, interim order continues till the next date of hearing. 120?
Dispensation of certificate copy of furniture.
ಅದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿದೆಯಾ? List the matter tomorrow in the fresh matters list. First time ಬರ್ತಾ 24th. List day after tomorrow in the fresh matters list. Password. ಏನಿದೆ?
Violation of rule 13D. 13D contemplates the
Notice.
procedure conduct in the office. So notice, they have not issued the notice, 13D has not been followed. So therefore, they have issued the notice direction to follow the 13D old election in terms of the directions of the judgment of this honorable. So that being agreed by that order, the repetitions have been filed. This repetition is filed.
Now election is stalled, is it?
Election is stalled, my lord. The annexure be issued by the election officer.
All right. Tomorrow in the fresh matters list.
Please.
List tomorrow in the election, we will finish it off.
Please.
No holding on.
Please.
List tomorrow in the fresh matters list. Yes. ಎಲ್ಲಿದ್ದಾರೆ? ಹಾ. ಅಪೀಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ? ಅಲ್ಲ, ಅಪೀಲ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ.
List tomorrow in the fresh matters. ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್? ಸಾರಿ ಅರಿಯರ್ಸ್ ಅಲ್ಲ, ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
As on 31 May 2024.
May see it on next Monday.
2 crore 13 lakhs
2 crores?
2 crores Allah, 72 lakhs is there are two sets of loans for 72 lakhs. So my lord, they have seized my property. So my lord, it is a running loss. There were TVs.
ಲಾಸ್ ಎಲ್ಲ ಬ್ಯಾಂಕ್ ಗೊತ್ತಾಗಲ್ಲ ಸರ್, ಕೊಡ್ಲೇಬೇಕು.
ಅಲ್ಲೆಲ್ಲ ಮೂವೇಬಲ್ ಇನ್ವೆಂಟರಿನೂ ಮಾಡಲಿಲ್ಲ, ಅವ್ನು ಸೇಲ್ ಮಾಡಲಿಲ್ಲ. For nearly 3 years without maintaining it, they kept it locked. And my lord, as far as I have paid the entire tax.
Who has kept it locked?
My lord,
Who has kept it locked?
bank my lords.
ಯಾವತ್ತು ಸೀಸ್ ಮಾಡಿದ್ರು?
ಸೀಸ್ ಟು 2022 ಗೆ 3 years ಅದನ್ನು ಓಪನ್ ಮಾಡಿಲ್ಲ. ಎಲ್ಲಾನು ಮೂವೇಬಲ್ಸ್ ಅದರಲ್ಲೆಲ್ಲ ಹಾಳಾಗಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ನಂದೇನಿದೆ
What is industry?
my lords,
Lodge.
lodging. ಅದರಲ್ಲಿ ಟಿವಿಸ್ ಇವೆ, ಇವೆ ಎಲ್ಲಾನು ಮೂವೇಬಲ್ಸ್ ಇವೆ. Once my lord, actually under surface act my lord, they should have made an inventory of my movables. Nearly they are to the tune of 1 crore. They should have sold it. At least they should have reduced down my loan. And at the same time my lords, I have already paid the entire tax of the property. The second time they paid it and they added it to my loan account. And for 3 years they have increased this interest amount also on that particular account.
ಮೇಂಟೈನಬಲ್ ಅಲ್ಲ. ಮೇಂಟೈನಬಲ್ ಅಲ್ಲ.
My lords, 34 ಕೆಳಗಡೆ ಯಾವುದೇ ಮೆಜರ್ಸ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇಲ್ಲ. So next Monday ಇಟ್ಕೊಂಡು ನಾನು ಅಲ್ಲಿ ಕನ್ವಿನ್ಸ್.
Twice, Lord, they approached this honorable court in writ petition, Lord.
Now my lords, I myself want to sell the property.
Bank is after the borrowers. Borrowers will come here only.
Lord, 8 times, Lord, we tried to conduct an auction sale.
ಈಗ auction
But, Lord,
ಆಗಿದೆಯಾ?
on one other, please, Lord, on one or other pretext, Lord, the petitioner approached this honorable court and by showing that tendency of
This is wrong my lords,
proceedings.
because of the
Lord,
bad condition of the.
purchaser or.
What is, even I want to sell the property by a private treaty. That's what I am saying.
List on 16th in the fresh matters list. It is made clear no further adjournment will be granted. Yes. Settlement ಆಗಿದೆಯಾ? ಮತ್ತೆ why did you settlement ಆಗಿದೆ ಅಂತ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೀರಾ? Which is that connected matter?
WP, in which already.
How long will you go on sir? 2010 matter 15 ವರ್ಷ ಆಗಿದೆ.
ಅವರು because compromise ಆಗ್ತಾ ಇತ್ತು ಮಿಲಾಡ್.
ಆಗ್ತಾ ಇದೆಯಾ? What compromise?
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡಿ ಮಿಲಾಡ್.
Sure. List on, I'll grant you 20th will post it. In the event there is no compromise, we'll decide. The learned counsel Muhammad Ali, representing the respondent, submits that if 10 days time is granted, the talks of settlement which are afoot AFOT would be taken to its logical conclusion. Therefore, list the matter on 20th as a last chance. Yes, next.
Kindly seek a week's time.
No, sir.
Next Monday.
2011.
No, I agree, it's a case of.
If you agree, then you should not seek adjournment.
No, case is pertaining to a case of a civil case.
So what? In civil judge ಆದ್ರೆ ತಗೋಬಾರ್ದು.
He is not present today.
Who is not present?
The party is not present. Let me advance argument in
Sir,
his presence.
ಪಾರ್ಟಿ ಒಂದು ನಿಮಿಷ. ಪಾರ್ಟಿನ ಕೂರಿಸ್ಕೊಂಡು ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ತೀರಾ? ಮತ್ತೆ ಸರ್, a colleague of yours was discharged, has filed a writ petition that is dismissed by Justice Anand Bhair. ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್? ಅದಾದ್ಮೇಲೆ ಸೇಮ್
Next Monday, today I will convince.
it is not stigmatic at all. That is what is held and that has become final.
I shall convince my lord on this.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಇಲ್ಲದೆ ಇರೋ ಸ್ಟಿಗ್ಮಾ ನಿಮಗೆ ಬಂದಿದೆ ಅಂತ
ನಾನು ತೋರಿಸ್ತೇನೆ sir. In my case, it is schematic.
in her case it is not stigmatic who was sent out with you. Same order. ಏನು ಇಲ್ಲ.
For that reason, we are week's time. Next Monday I will.
Finally.
That's fine.
Yes, first day and last.
Yes.
Otherwise, this 2010-11 will please don't seek adjournment. We have to close it. List the matter at the next Tuesday, Wednesday, I did that. 16th. List the matter on 16th at 3:30 p.m. It is made clear no further adjournment would be granted on whatsoever ground. The learned counsel Mallikarjuna Swami Hiramat submits that the co-employee who was also discharged along with the petitioner by the same order had called the said order in question in writ petition 40567 of 2011, a coordinate bench rejects the claim on all pleas, PLEAs, of the said petitioner in terms of its order dated 17th January 2012. The said order is said to have become final. The learned counsel submits that he would seek to distinguish the said judgment qua the present petitioner. List the matter on 16th at 3:30 p.m. as a last chance. Yes.
Submission was 129 and 130. Not filed at all. Senior was appearing for the response. My senior was appearing for the response. His elevation law. Filed laws are not taken. I'm on the panel of.
ಯಾವಾಗ ಆಗಿದೆ elevation?
Please.
Elevation ಯಾವಾಗ ಆಗಿದೆ? ಮತ್ತೆ?
No, but ಏನಾಗಿದೆ this file, both the files.
ಎನ್ನೆ ಮೊನ್ನೆ ಆದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
I don't have lot these files.
One last chance to everyone. ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ.
I'm on the panel, but
Correct. At the request of counsel, ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ವಾ? ತೋರಿಸಿದಲ್ಲ.
because so that the matter does not go
ಇದರಲ್ಲಿ if the family is getting any benefit, please give. ಅಷ್ಟೇ. Otherwise case ಇಲ್ಲ. ಇವ್ರು ಕೇಳೋದೆಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ.
It's on regularization.
Regularization. Some benefit if the family is going to get.
I ascertain that also.
List the matter on 16th at the request of Prashant Hosmani as a last chance.
129 and 130.
129, 130 also. Allah, 130 ಯಾರ್ದು? 130 has spent itself 6 months increment, postponement of increment without cumulative effect. It is restored 10 years ago. Then what's that?
I did not have the file number, that's why.
130. There is a KH Bagi. ಇದು increment ಅಲ್ವಾ, ಅದಕ್ಕೆ 4 ಪೇಜ್ ಇದೆ petition. The petitioner is before this court seeking the following prayer. Heard so and so. The issue in the list revolves around a narrow compass, as the challenge is to an order of the disciplinary authority dated 21/9/2011, which imposes a penalty of stoppage of increments, stoppage of one increment for a period of 6 months without cumulative effect. In the light of there is no interim order granted at the hands of this court. Therefore, the penalty has spent itself, and the increment, since it was without cumulative effect, has got restored way back in the year 2011. The challenge to the petition, the exercise of jurisdiction under Article 226 of the Constitution of India today would become an exercise in futility. This court would not issue futile writs. Therefore, the petition is disposed on the aforesaid. ನಿಮ್ಗೆ ಹಿಯರ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟೇ ಇರೋದು, 6 ತಿಂಗಳು ಆವಾಗಲೇ ಆಗೋಗಿದೆ. It is restored also because it's without cumulative. With cumulative ಅಂದ್ರೆ he lose everything. Yes. Next. No time, sir. Tomorrow. Why? Misappropriation. Misappropriation.
Is not exhausted the remedy available under ID Act. He is a clerk.
ಯಾವ ಐಡಿ ಆಕ್ಟ್ ಇಲ್ಲೇ ಕ್ಲೋಸ್ ಮಾಡೋಣ, 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಅಲ್ಲಿಗೆಲ್ಲ
He has to approach the CJIT, labor court.
ಯು ಆರ್ ಚಾಲೆಂಜಿಂಗ್ ವಾಟ್ ಆರ್ಡರ್, ಸರ್? ಇದು ಮರ್ಸಿ ಪೆಟಿಷನ್ ಸರ್. ಅಲ್ಲಿಗೆ ಮತ್ತೆ ಎವಿಡೆನ್ಸ್ ಮಾಡ್ತೀರಾ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಹೋಗಿ? ವಾಟ್ ಇಸ್ ದಿಸ್? ವಿ ಕ್ಲೋಸ್ ಇಟ್ ಹಿಯರ್ ಓನ್ಲಿ. ಮಿಸ್ಅಪ್ರೋಪ್ರಿಯೇಷನ್ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಇಲ್ಲಾದ್ರೂ ಅಷ್ಟೇ, CJIT ಇಲ್ಲಾದ್ರೂ ಅಷ್ಟೇ, ಎಕ್ಸ್ಟ್ರೀಮ್ಲಿ ಲಿಮಿಟೆಡ್. ನಾಳೆ ನಾಡಿದ್ದು, day after tomorrow.
Please
look into 2022 5 SCC page 202. Yes. ಬರ್ಕೊಂಡ್ರಾ? ಬರ್ಕೊಳ್ಳಿ. Yes, next.
Or in this matter, or identical case, my lord.
Yes, yes.
This is relief against the KPCL, my lord.
Identical matters have been already disposed of before the principal bench and order is released on 4/12, my lord. It is not yet uploaded in the.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಆರ್ಡರ್?
I have to secure the copy online or upload on.
ಆಗಿಲ್ಲ ಅದು okay, now that is.
ಏನ್ ಮಾಡುವ? 10 days ಬಿಟ್ಟು ಹಾಕ್ಲಾ?
Next Monday, my lord.
Next Monday.
That copy is.
I'll post it on 20th, ಅಷ್ಟರಲ್ಲಿ ಬಂದಿದೆ.
Even otherwise, your lordship can dispose of, because the order what was in challenge is already being default.
But that has been brought to the notice of this honorable court before the principal, and now a final order has been passed. That same authorization has to be passed.
ಆಯ್ತು, ಬರ್ಲಿ ಬಿಡಿ ಕಾಪಿ. ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಆನ್ 20th in the fresh matters list. ಬಂದಿದ್ರೆ ಮುಗಿಸ್ಕೊಂಡು.
Please.
Yes. We'll send it back. Violation of natural justice is your ground. Amata?
One aspect of the matter, what has happened was the petitioner was engaged in the activity of construction of petrol pumps. He was not under the impression, he was under the impression that no service tax is not in applicability. So under your circumstances, he was.
Sir, mistaken notion ಗೆ no relief. ಕೊಡ್ಲೇಬೇಕು. ಕೊಡಿ. ಅಲ್ಲ ಅದಕ್ಕೆ let them consider that and send it back. Here ಮಾಡಿಲ್ಲ ಇವ್ರನ್ನ.
Here, Madhya Millards, thereafter order in original has been passed, and against that order in appeal has been preferred before the appellate authority.
Pending or closed?
It is closed, Millards, and the appellate authority has dismissed the appeal on the ground of delay, Millards.
Delay? Why?
Yes, Millards. Delay in preferring the appeal, Millards.
When was the order of the original authority?
Let's read two paragraphs, page 36. So the moment he was intimated to us, he paid even before the issuance of show-cause notice. So very issuance of show-cause notice itself is not bad enough. And this is not paragraph 7, page 36.
ನಿಮ್ಮ ರಿಪ್ಲೈ ಅಲ್ಲಿ?
Some reply, it is not at page 29, not precisely not page 30.
Why issuance of show cause notice is bad in law?
Because not even before the issuance of show-cause notice, I have complied with the requirements and I paid the entire amount.
It is not so, Millards, because Millards, it is the case of the department that, Millards, without obtaining the service tax registration, he has carried on the business. And after noticing that, they had obtained the service tax registration. But for the period which he has not obtained the registration, Millards, service tax has been demanded under section 72, Millards. And thereafter, Millards, under section 77.
Which is that period which you are working with, where there is vacuum?
And listen, page 30.
Page?
Page 30. On being pointed out by the preventive officers with regard to leviability of the service tax on setting up of petrol pumps, we immediately completed the registration formalities.
And you paid everything without.
Everything.
There was no dues.
No dues.
ಯಾಕೆ ಕಾಟ ಕೊಡ್ತೀರಿ? ಎಲ್ಲ ಕೊಟ್ಟಾದ್ಮೇಲೆ ಏನು?
Millards,
For your satisfaction, you should not do it.
19/6/2009 I have paid because they issued the show-cause notice on 10/10/2013. 19/6/2009 I have paid. 10/10/2013 first show-cause notice.
Millards, it is the case that, Millards, is from 2008 to March.
ಆಯ್ತು, ಅಲ್ಟಿಮೇಟ್ಲಿ ನೀವೇನ್ ಮಾಡ್ತೀರಾ? ಪೆನಾಲ್ಟಿ ಇಂಪೋಸ್ ಮಾಡ್ತೀರಾ.
Yes, Millards, that what I.
It's all right. He has paid everything with penalty.
With penalty.
Millards, the demand is, Millards, for the amount of rupees 19,35,000 Millards.
And interest of
But
4,06,000 I have paid.
All do you admit entire amount being paid, sir?
Yes.
Millards, it is in respect of the payment of the amount, Millards, there are no averments and documents are.
ಅದೇ ಮೇನ್ ಅವರ್ಮೆಂಟ್ ಅದು ಪೇ ಮಾಡಿದೀನಿ ಎಲ್ಲ ಅಂತ.
Millards, it is not so, Millards, but
It is there.
If you see the writ petition averments, main averment is that he has paid the entire amount.
It is admitted even in the order also that has been passed.
Millards, after obtaining his service tax, he has paid the amount, Millards. It is the.
ಈಗ ಬಟ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ವಾಟ್ ಕೆನ್ ಯು ಅರೆಸ್ಟ್ ಮಾಡ್ತೀರಾ? ಪೆನಾಲ್ಟಿ ತಾನೇ ಮಾಡಿದ್ರೆ.
Penalty,
With
Millards,
penalty he has paid everything.
Millards, it is not so, Millards. The penalty has been confirmed, Millards. Penalty amount has not been paid. That order is being challenged before this court, Millards.
I just read two paragraphs, page number 36, that is the included order.
Millards, with respect of the payment, Millards.
Kindly see notes. Page number 36, paragraph 7. The superintendent SP Belgaum made a reference to the proprietary
Evidence.
Void order dated seeking the details of the service provided and payment.
ಇಲ್ಲ, ಇಲ್ಲಿ ಬನ್ನಿ ಇಲ್ಲಿ. Further, I also find from records service provider vide his letter dated so and so submitted copies of ಆಮೇಲೆ payment of interest ಅಲ್ಲಿ ನೋಡಿದ್ನಲ್ಲ ಈಗ service tax ಅಲ್ಲ evidencing payment of service tax and interest amounting to 20,64,849 ಸುಮ್ಮನೆ ಇಂಥವೆಲ್ಲ ಎಲ್ಲ ಕಟ್ಟಾದ್ಮೇಲೆ ಇನ್ನು maximum is penalty you can impose.
Penalty can be imposed.
You have imposed penalty.
For the contravention of the.
You have imposed penalty, he has paid penalty. What for this petition is pending? Or why did you initiate proceedings? You notice kodak ಮುಂಚೆನೇ ಎಲ್ಲ ಆಗೋಗಿದೆ.
It is not so much.
Just your officer records it, sir.
Paragraph 8 also may kindly be seen. They also said that I don't have the intention of evading the tax. That is their money.
Penalty for the fraud has been
fraud.
Fraud.
You don't say it is fraud. Sir, you don't say it is fraud. You don't say it is fraud.
Please,
his defense, you have accepted that he did not know that those works contract also would come within the ambit of tax. That's all.
Paragraph 8 is very clear. I'll read it. As regards imposition of penalty.
ಅಲ್ಲ ಇದಕ್ಕೆ 10 ವರ್ಷ 12 ವರ್ಷದಿಂದ ಯಾಕೆ ಪೆಂಡಿಂಗ್ ಇದೆ? ಅಲ್ಲ 2016 9 ವರ್ಷ ಆಯ್ತು.
Objection statement ಎಲ್ಲ ಇದು ಮಾಡ್ಕೊಂಡು
ಆಗಿದೆ Malad, with respect of the payment
for a 2-minute job 9 years in the pending.
Please, Malad. Last Malad, in the last occasion the matter was heard, Malad, for 2-3 times, and except that, Malad, the matter has not been listed. Malad, with respect of the payment, Malad, I'll just seek a clarification.
No clarification. Your order, sir, your order speaks for itself. Will your officer give you some other clarification than the order that he has passed?
There was charges of the offence was 77, 70, 76, 77, 78 Malad.
That is what I am asking.
Dropped, Malad.
That is what I am asking you.
Please, Malad.
All these actions of 77, 78 of violation or the non-payment of tax will result in imposition of penalty.
Please, Malad.
If it's a penal provision and 273, 272 authorized heading, it is only violation of penalty matra imposable. Service tax is there. Penalty matra imposable. Penalty already imposed.
Malad, I may be permitted to take your lordships to the only one relevant paras, Malad. Malad, there is a 100% penalty, Malad.
ನೀವೇ ಡಿಟರ್ಮಿನ್ ಮಾಡಿರೋ penalty.
100% penalty for the contraventions of the rules is there, Malad. When the tax has been, the tax determined, Malad, is 19,35,000 Malad, and the same amount as penalty is, Malad, 3,90,000 Malad. They had deposited only the 20 lakhs around odd amount, Malad. In respect of the penalty, Malad, there was a dispute. I may be permitted lordships to 38 Malad.
Page 37.
38
Malad.
1 minute, Gurudev.
37 last para is the orders, Malad. Wherein?
Page 37.
Appropriation of interest 3,90,000 paid during investigation towards demand. Adu pay ಮಾಡಿದ್ದಾರೆ ಆಯ್ತಾ? I impose penalty under section 76 of the Finance Act, failure to pay service tax by the due date.
Please, Malad.
ಆಯ್ತು penalty impose ಮಾಡಿ ತಗೊಂಡಾಗಿದೆಯಲ್ಲ.
Penalty, Malad, only the amount has been amount.
Sir, clause E at page 38.
Please, Malad.
ಅದು ತಗೊಂಡಾಗಿದೆ. 3,90,000 is also towards demand appropriated.
It has been appropriated, Malad. Malad, whereas they had only paid 20 lakhs rupees, Malad.
ಮಿಕ್ಕಿದ್ದು appropriate ಮಾಡಾಗಿದೆಯಲ್ಲ ಈಗ.
ಅಲ್ಲ paragraph 8 ಅಲ್ಲಿ ಅದೆಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿ ಒಪ್ಕೊಳ್ತಾರೆ. I just read one as regards imposition of penalty under section 78 of Finance Act. I find from the case regards the service provider has responded immediately to the department's letter dated 22/5/2009 seeking details of the service provided and payment of service tax. Thereafter, the proprietor responded to the department's letter, discussed with the issue with the preventive superintendent and applied for the service registration online. He has not contended for payment of service tax. Instead, the experts they were unaware of the fact that the services provided to the clients were chargeable. He has obtained service tax registration on 1960 and paid the service tax during, along with the interest and late fees for the filing of ST returns. Hence, I do not find any suppression of facts. The service provider has discharged all the service tax and interest liabilities which act of them clearly shows that there is no malignant intention to evade duty or an intention whatsoever to willfully evade the provisions of the service tax.
Yes, sir.
And yet I accept
The petitioner Firma idu proprietor. The petitioner, a proprietorship concern, is knocking at the doors of this court in the subject petition, calling in question an order dated 7/1/2014 and 28/2/2015 and all other subsequent orders passed by the